Hi, and welcome back to the third video, the 10th lecture of Covidenomics. In this 10th lecture, we've been looking at issues relating to data, how data can be used to fight COVID-19, and more broadly, what data is, what sort of good is data. In this final video for this 10th lecture, I want to look at two specific things. The first off is the issue of data and competition. A slight detour from focusing on the pandemic, but it raises a whole bunch of really interesting issues that come up again and again in the media, in anyone looking at industry policy. The second thing that I want to look at is what I'll call data policy. In other words, looking at what different countries are doing around the world to deal with data and to work out how individuals or companies or governments can have rights or ownership over data. And I'm going to focus on two approaches. The first is the EU's General Data Protection Regime, or GDPR, which is an ownership-based regime. The second is an approach that we're using in Australia and is also used in other countries, which is associated with data rights. And sort of unsurprisingly, seeing as the Productivity Commission has pushed for consumer data rights in Australia, I think that second way is the way to go. I'm going to end up, though, by arguing that what we have learnt from the pandemic is that not only do we need data rights for business and for consumers, we also need them for government. And it's that government data right that is lacking that has meant that most Western countries haven't been as successful as, say, South Korea and Taiwan in fighting the pandemic. One way that business is using data is to be able to better target advertisements, discounts at individuals based on, for example, their search history. This is not new, however. Whilst technology has made it easier to use individual data to target discounts and sales of particular customers, it's been around for a long time. Data based on store loyalty cards or your credit debit card history has long been used by retailers to be able to target advertisements or discounts at particular customers. This goes back well before current issues of internet and search advertising, and involves, for example, paper-based vouchers, vouchers that used to be sent out in the mail. One of the most well-known examples where this targeting strategy went wrong involves the retailer called Target. Charles Duhigg from the New York Times wrote a piece looking at how Target, the retailer, had employed statisticians to look into their data that they were busy collecting from their customers, to be able to analyse that data and send out vouchers by mail to individual customers, and trying to work out what vouchers those customers would most value. One of the categories that they looked at were women who were likely to be pregnant. And they noticed that certain buying patterns by women shoppers tended to suggest that the relevant customer was in fact expecting a baby. An example, though, of how this approach could go wrong occurred in Minneapolis when an angry man turned up at a Target store and demanded to talk to the manager. He showed the manager the vouchers that his teenage daughter had got in the mail, sending her coupons for baby clothes and cribs. And the man accused the store of trying to encourage her to get pregnant. Now, the individual store manager had no idea about this. The vouchers were sent out centrally based on aggregated data across all of the Target outlets in the United States. But he apologised to the relevant man and in fact rang back a few days later to apologise again. However, when he rang back, the man was somewhat abashed. Apparently he had had a chat with his daughter and, I quote, "It turns out there's been some activities in my house I haven't been completely aware of. She's due in August." Target very quickly worked out that targeting pregnant women was considered by their customers to be really, really creepy. Often Target would start sending the vouchers even before the customers had confirmed their pregnancy, sometimes before they told their partners. And Target pulled back from that strategy. However, as technology has advanced and we've got more and more data and much quicker turnaround in terms of being able to get targeted ads by using the internet, the sort of activity that Target got burnt with has in fact blossomed on the internet and is still creeping some people out. A well-known recent example involves the company Facebook and a data company called Cambridge Analytica. Cambridge Analytica developed an application that, with the consent of Facebook users, gathered some data from those particular users. However, it didn't stop there. Facebook also allowed the application to not just collect the personal information of the people with the app, but also from all of the Facebook friends of those people. So by using this application, Cambridge Analytica managed to gain a huge data set from millions of Facebook users. Having got that data on millions of people, Cambridge Analytica used it and sold it for political purposes to help politicians target advertising that would influence people's vote. This started way back in 2015, but occurred through the presidential election in 2016 and really only became public in 2018, even though a fair bit was known about it by then. When it became public, people were shocked, they were scandalised. $100 billion was knocked off Facebook's market capitalisation in only a few days. Politicians in the US and the UK demanded answers from Facebook and Cambridge Analytica. By mid-May 2018, Cambridge Analytica and its British parent, SCL Elections Limited, had shut down and filed for bankruptcy. The Facebook Cambridge Analytica scandal shocked people. What I found shocking was how shocked people were. After all, whilst Cambridge Analytica and Facebook went beyond the norm in that they collected data without even asking customers' permission, how many people actually read through the terms and conditions they have on Facebook? How many people realise that when they sign up for Facebook, Facebook is able to collect data not only relating to Facebook, but from any other applications that you have on your relevant device? So the real question should be not that we're shocked by this sort of behaviour, but rather that we find it shocking. After all, what do people think Facebook is doing with their data other than monetising it? The level of data aggregation by significant internet companies such as Facebook, such as Google, such as Apple, has caused concern for competition authorities. For example, when Facebook wanted to take over the messaging application WhatsApp back in 2014, the European Commission was concerned about Facebook bringing together its data with WhatsApp data, the aggregation of that data. Facebook, in fact, claimed to the European Commission that it was impossible to do that because of the different systems they had in place, Facebook would not be able to simply incorporate WhatsApp's data into Facebook's data, but they would have to keep two separate, disconnected data sets. And given that representation by Facebook, the European Commission allowed the merger to occur. The only problem was the representation was incorrect and misleading. So that in 2017, the European Commission fined Facebook €110 million because after the merger had occurred, it had started to aggregate the data from WhatsApp together with the data from Facebook. This fine might sound pretty big, but from the perspective of Facebook and WhatsApp, it may have been a small price to pay to be able to get all of that extra data. The European Commission decided that it wouldn't reopen the whole merger investigation. It said that the issue of data aggregation wasn't the only factor in clearing the merger. And in a few minutes, we're going to ask, well, is there really a case against companies like Facebook that they could end up with too much consumer data? But really the lesson from the Facebook WhatsApp decision and fine is that it's pretty hard for competition authorities to stop the sort of data accumulation that we're seeing, whether they think there's a competitive problem or not. One innovative approach that has been used to try and limit this data accumulation under existing competition laws is from the German Cartel Office. The German Cartel Office ruled that Facebook was abusing its market power by requiring consumers to sign up to terms and conditions on a take-it-or-leave-it basis that forced those users to share data from not just Facebook, but other services such as WhatsApp and Instagram, which are owned by Facebook, and also third-party websites, to share all of that data with Facebook. So they're part of Facebook's terms and conditions. The German Cartel Office said that Facebook has market power, it's a dominant social media player in Germany, and that use of its contract, its take-it-or-leave-it requirement on consumers, gave private Facebook users no choice, and hence was an abuse of that market power that Facebook has. I will confess that I really like this approach by the German Cartel Office. If they're successful, and it's still working its way through the courts, if they're successful, it will mean that companies like Facebook can only collect the data from consumers that they need to provide the relevant services to consumers. They simply can't do this let's trawl all your data up and see what we can do with it type approach, which they have in the past. And I think that gets close to the sort of approach where we have rights for consumers. Yes, Facebook can require you to provide some data, they need it for the service, but you have a right as a consumer not to provide any more data. We're going to get back to consumer data rights when we get onto policy, but first, there is still one more case that we need to think of. And that is the ongoing merger, at least whilst I'm making this video, between Google, the internet search giant, and Fitbit, a maker of wearables, things that you put on your wrist that not only tell you the time but collect a whole bunch of health data about the wearer. A number of economists, including a couple of my co-authors, have recently put out a paper arguing that the European Commission should intervene in this merger, either disallowing the merger or imposing strict conditions. They have a number of competitive concerns. Some are fairly standard. For example, the concern that if Google, which has operating systems on Android phones, if it owns a wearable product, then it will tend to favour its own wearable product, and that may make it harder for other wearable products to compete when they need to interact with Android's operating system, which is owned by Google. However, the key novel concern relates to data. Their concern is the bringing together of Fitbit's health data with Google's what is sometimes called a data fire hose. Data about pretty much anything else you can think of from their consumers. And the concern is that the use of this data will enable Google to abuse consumers and may make competition in areas of health technology or areas of health insurance more difficult. What I want to do, though, is to ask, well, what does the economics actually tell us about data and these sorts of mergers? Do we have to really be worried about firms collecting too much data? Unfortunately, the answer is, well, yes and no. On the no side, we know that better data can help companies better service consumers. Sometimes it's said that data companies sell that data to advertisers and they target consumers. That sounds bad. But for those people like me, old enough to remember when Amazon started as a bookstore, one of Amazon's big competitive advantage out of internet booksellers was that it used data about what books I'd looked at, what books I'd searched, to provide recommendations. And they were great, because rather than me having to troll through literally hundreds of books to find the one I wanted, Amazon could tell me, hey look, based on your data, we think you'll really like this book. And more often, they were right rather than wrong. It was a great service. And in some ways, the targeted internet advertising that we get today is similarly a great service, because you get told where you can buy a product at the cheapest price, something that we like. Second, increased data held by private businesses can actually increase competition. This is most obvious when we're dealing with symmetric data. In other words, when two or more businesses out there are competing for our custom and they know exactly what we want, which means that they will be fighting tooth and nail to get our business by providing a product which is pretty close to exactly what we want and what we need. Think of it this way. Imagine there are two Italian restaurants and you're thinking of going to one or other of them for dinner. They may know nothing about you, in which case you go in and you can order the average pasta. It's going to be pretty similar between the two restaurants, but let's face it, it's going to be average. Now me, I like spices, capers, lots of olives, lots of garlic. So I would really much rather prefer the situation where I could go into those restaurants and they knew my tastes and I was able to say to them, look, I'm not sure where I'm going to eat tonight. Which of you wants my business? Who's going to offer me the best spaghetti that meets my tastes? That's more likely to get me a really good deal on something that I really want. So having symmetric data can actually increase competition. It can make competition, in a sense, go on steroids, because each of the competing providers know that the only way to get your business is to really give you what you want. The same can actually hold even if data is asymmetric. Let's suppose that one business has lots of information about you. Another business also wants you to buy from them. They don't have the information, but they know that the rival does have the information. Then, even though they don't have the information, they may compete hard for your business, recognising that unless they offer you a really good price, they're not going to be able to overcome the data advantage of the other business. Of course, if they drop the price, that forces the other business to compete hard as well. So we can actually get increased competition when data is either symmetric or when it's asymmetric. Unfortunately though, this asymmetric case is ambiguous, and asymmetric data can also lower competition. Think of it this way. The business that doesn't have your data, they could compete really hard through the price. That's the only way they can compete. But they may also say, it's just not worthwhile me putting in the effort to compete for that customer or that group of customers. my rival has lots of information on them. I know I'm never going to be able to beat my rival because I've got an information disadvantage. I'll concentrate on other customers. Or in other words, the asymmetric information may effectively lock you out of competition and mean that you're in some ways at the mercy of those companies that have that better information. How do we know if the asymmetric data is going to help or hurt competition? The answer is, without knowing explicit details about the industry, we can't tell. And finally, there can be situations where data about a consumer makes them undesirable from the seller's perspective. In other words, there can be, in a sense, bad data from the consumer's perspective. A couple of simple examples. If you're out buying health insurance and the health insurers know that you smoke too much, drink too much and are overweight, that data is going to lead them to say, we're going to be selling you a policy at a very high price. Or if you're out there buying car insurance or renting a car and the salespeople say, we know you are a very bad driver, you've had lots of accidents recently, then you're going to get a very high price. So there are situations where data can actually hurt the consumer by showing that consumer to be of a type that is costly from the seller's perspective. You might think, well, that bad data, okay, maybe we should just have a law whereby the firm can't get that data and can't force me to provide them with the data that I smoke too much or I drink too much. The only trouble is that law's probably not going to be effective because there's also going to be customers who are great drivers or don't smoke or drink, and they want the seller to know that. So if the seller says, look, you don't have to give me information about your accidents, you don't have to provide proof of whether you've had accidents or not, that's fine, but you can if you want, then all the safe drivers are going to say, yeah, I want to get a discount because if I give you that information, I'll get a cheaper price. So the seller's just simply going to infer, if you don't give the information, you must be a bad driver and they'll charge you a high price anyway. So that sort of unravelling, as it's called, can mean that even if you have rules saying that sellers can't demand information, buyers may be stuck in the situation where they'll give up that information to the seller anyway, knowing that if they don't, they'll either face a high price or not get the product at all. So this leaves us in a really, really annoying position. Sometimes businesses having more data about us can improve competition. It can improve their service offerings, and it can make businesses fight harder. In other situations, businesses having more information about us may harm our interests, may mean that we get charged higher prices, and may stifle competition. That's a problem. How have governments responded to this, both at the specific competition law level and at the more general policy level? Well, we've already mentioned one approach. That's the approach being pursued in Germany against Facebook, which is to place limitations on the amount of data that a business is allowed to collect about its consumers. The second approach is to mandate data sharing. Now, there's different ways to do this. For example, as I'm making this video, the European Union is preparing its Digital Services Act regulation. An early draft of that regulation shows how they're thinking about forcing companies to share their data. So, for example, companies like Amazon and Google, according to the draft, shall not use data collected on their platform for their own commercial activities unless they make it accessible to business users active in the same commercial activities. In other words, if one company has significant data on you, they have to share it with their competitive rivals, not something they would generally do otherwise. An alternative approach to data sharing has been adopted in, for example, Australia and the UK for banking. Open banking in both of those countries means that consumers can require their current bank to pass information about them, about them, the consumer, onto other competitors. So for example, if your current bank has all your credit history, they know whether you're a good or a bad credit risk, you can say, well, hang on, I want your rivals to know about that so that they can offer me a home loan or a credit card or some other product, and you can require the bank to pass that information on. Notice that the idea of both of these approaches, either the business being forced to share by its competitors or the consumer having the right to demand that their information is shared, both of them are trying to get around this problem that asymmetric information or asymmetric data may be anti-competitive, but symmetric data is generally competitive. What they're both doing is trying to make sure that the data is symmetric. A third approach is to threaten to somehow punish big tech, for example, by breaking it up, by requiring, for example, that Facebook sell WhatsApp and sells Instagram, or requiring that Google divest its stake in Android operating system. Those sort of punishment approaches, however, well, it's not clear often exactly what they're trying to achieve. And of course, they could make things worse if you end up having, for example, Google breaking into a number of companies that don't compete with each other, and they just have worse data. It may mean that they have worse services, and that won't be in the consumer's interest. As I noted, these are really live issues. In fact, while I've been making this video, the United States House of Representatives Antitrust Committee has just released more than 440 pages looking at competition in digital markets. So we're pretty close to the frontier on models dealing with big tech. However, what about more general issues of data in our economies? Here, the responses have been sort of two alternative approaches. So in looking at data in general, countries have either gone down the direction of data ownership, the idea that consumers or individuals own their own data, and that they can require, for example, a business that has that data to erase it, to get rid of their memory. Alternatively, there's an approach around the idea of data rights. Under data rights, consumers have certain rights over their data, but so do businesses that help them create that data. One example of the data ownership approach is the General Data Protection Regulation, or GDPR, from the European Union. It was put in place in 2018. It applies to individual data, where that's defined as being any data about a person that enables you to identify the person, either directly, it may have a name or address, or it may be indirect. For example, it may be a cookie that is on your computer, it's on your computer, and therefore able to pretty clearly identify you as the user. A key feature of the GDPR is that you can require a company to identify what individual data it has about you, and then you can require that data to either be transferred to some other business, or you can require it to be deleted. In other words, you can require that that business erase that data, and that if it has sold it on to any other parties, that that data is also erased by the other parties. It's really this right to erasure which is so strong in the GDPR, because it says that the business that has helped you create that data, in fact, has no rights over that data. It can't simply say, no, we want to keep it, if it can be used to identify you, the individual. Now, it could be anonymised and included in a bigger data set, but if it can identify you, then you can demand that the company gets rid of it. In contrast, in Australia, we're moving down the path of a consumer data right. Open banking is the first practical application of this idea, but it's planned to be rolled out into other industries. The difference between a data right and data ownership is that the consumer has specific rights over the data, but the business that helped create the data also has certain rights. The consumer just simply can't say, look, remove that information about me from your systems. I don't want you to have that information. However, the consumer does have rights, for example, to require that that information is passed on to a competitor that the consumer wants to deal with. This distinction between rights and ownerships may sound pedantic. It's not. In my opinion, rights reflect the economic nature of data. Most data you don't simply create yourself. Yes, your name or your birthday would be data that you say, yep, it's mine. I don't need anybody else to create it. But think about if you go to a doctor and create some medical data. Your whole point of going to the doctor is that you don't know what's wrong with you. The doctor also can't do that without your cooperation. They can't tell you what's wrong with you. They can't create your medical record without you. And in fact, there may be pathology labs because tests may be run. So that data that's in your medical records is, in a sense, a joint product of yourself, your doctor, your pathology labs. It may also involve the government in countries like Australia, where the government pays for a substantial part of our medical system. By making it clear that parties have rights over that data, we avoid the sort of conflict that we see currently in countries like Australia and elsewhere, where it's not clear who actually owns medical records. Are they the patient's records? Are they the health insurer's records? Are they the doctor's records? Where does privacy come in with those records? We don't even know who owns them. So how do we deal with privacy issues? A rights approach recognises that all the parties have some rights over those data because they're jointly created and have joint uses for all of the relevant parties. The creation of a system of data rights for both consumers and for business was a key part of the Productivity Commission's inquiry into data availability and use back in 2017. And it's underpinned the move towards data rights in Australia and also in some overseas countries. So government policy for data based on a rights approach rather than an ownership approach really reflects the two key economic principles for data. Firstly, that it's non-rivalrous, that you can have your data, so too can your doctor, so too can your health insurer. You can have your data, so too can your bank, so too can some competing banks. It also reflects that data is this joint product, that most valuable data is created not just by an individual, but is created by a system, that it's our search activity on Google which creates the data that can then provide information about what we may be interested in buying, often providing information that even we would not have recognised if it hadn't been put together and put to us. Data rights can also help overcome those competition issues. As I mentioned before, both data rights and data ownership can be used to overcome the problems of asymmetric information, trying to make information symmetric in the marketplace and therefore improve competition. But let's come back to COVID-19. We've seen in the previous video the importance of data in South Korea, Taiwan, and some other countries to help fight the virus. Why haven't we seen similar efforts in many Western countries? Well, you can see the problem if you have an ownership regime for data. Because if a consumer owns their data, then the government has no rights to use it. And the government can only essentially ask the consumers, can we use your data? And if the consumers say no, well, there's nothing the government can do about it because the consumer owns the data. Even if that data has been created by mobile telephone companies and the consumers, by government records with the consumers, by payment cards and the consumers, the government can't do anything about getting that data because it's owned by the consumer and the consumer can simply refuse. Conversely, if we think about a data rights regime, then the real problem there is that we talk about consumer rights and we talk about business rights for data, but certainly here in Australia we haven't necessarily thought hard about the government's right to data. So in an emergency, should the government have the right to certain data about individuals, particularly if those individuals have tested positive for COVID-19 and potentially have spread it around the community? At the moment, the government has no such rights. But I think what COVID-19 has done is to show that we need to think about government rights over individual data, or data relating to individuals, to be more precise, and what restrictions need to be placed on government, what rights government have, and when governments can exercise those rights, so that we're ready for the next pandemic and we can respond much more quickly and help avoid a pandemic, avoid the economic damage, and avoid the health costs, such as has been done in Taiwan, South Korea, and some other countries that were prepared. I think this is really an issue that we've got to discuss once this pandemic's over. Thanks for listening. Talk to you next time when we're going to start thinking about how we move out of lockdown and get the economy back on its feet as the pandemic winds down. Talk to you then.